In the box corner.
Yes, are you ready to proceed on this?
Yes.
All right, Mr. Washington, if you come down. All right. So the new, and counsel, you're on this side.
Oh, sorry.
On the wrong side.
Good morning. Oh, no, you're in the center. It's just your client is on this side. All right, so the court is in receipt of the newly indicted case. Counsel, are you on that case as well?
Yes, Your Honor.
All right, so state, where are you on discovery with regards to your case?
I believe defense requested things this morning. We provided her with 911 call. We're requesting another police report that might be missing. So we're in the process of trying to get all that to defense.
All right, is there any child protective services involved in this case?
Correct.
All right.
That's another, Your Honor, if I may, we do not have CPS records. That's one thing that I'm requesting this morning. What the state indicated was, the 911.
Everyone, please whisper.
The 911 call that I have in evidence is an opening, so they're putting it on a CD for me to see if that helps. I've also asked for an additional audio files for them to check with their detective. There are emails in discovery indicating that the detective spoke to the complaining witness's parents, and I'm asking them to check with their agency to see if there's any audio files that recorded that conversation, because
All right,
sometimes.
so
they
you
haven't.
need to have a seat.
Additionally, Judge, I'm requesting SAPD 2404-6370, which is the original runaway case for this complaining
All right,
witness.
so let's slow it down a little bit.
Sorry, Judge.
Everyone, for the love of all that's holy, please whisper. Whisper as though you are spies. And if somebody can hear your conversation, that will mean the end of your life. All right,
Can I continue, Judge?
Bashan. Everyone here, if they were a spy, it would be over for them. Everybody would hear their conversation. All right, so you need CPS records.
Yes, Your Honor.
There are some audio files that may exist based upon your review of emails.
Yes, Your Honor.
All right, do you have all of the emails?
Yes, Your Honor, they're in discovery and I can forward them to the state if that would.
All
be
right, so
helpful.
what else do you need?
Your Honor, there's a runaway case for the complainant that's connected to this case as well. I've given him that SAPD report number, Your Honor, and I'm requesting the discovery in that case.
All right,
Additionally, Judge, when the detectives speak to the complaining witness's parents, they indicate another person who may have been the cause of this. His name is Joseph Cortez. So I have requested the at-large case, which is JN 2171232. The state indicated that they would upload the police report, Your Honor, but I'm requesting all of that discovery because that is going to be important when I'm cross-examining all of the witnesses, Judge.
all right, so,
Your Honor, for the record, that is sealed evidence.
oh, we're not on the record, but okay.
Well, that's sealed evidence and it's not, can't be provided for discovery until the state decides if it's going to be indicted or not. It's an unindicted case,
All right, and this is
unindicted at large
on Cortez?
on the one she's referring to at the end. Yes, Your Honor.
Cortez?
Yes, Your Honor.
All right, so just file your motion for that. If they don't turn it over, we'll have a hearing.
Yes, Your Honor.
And state what I can tell you, if the defense cannot wait for you all to decide if you're going to indict a case or not, unseal it or not. Because this may be a witness that may be exculpatory, maybe it's not, who knows?
Understood.
But if it's not turned over, file a motion and I'll have a hearing on it.
I will, Your Honor. Thank you.
All right, is there anything else?
No, Your Honor, after our last hearing, they uploaded body cams, Your Honor, and from the SB, from the report that the detective put together, I believe that's all the body cams available, Judge, and from my view of the evidence, I don't believe we're missing any body cams. It's just what I indicated on the record today.
All right, so we're gonna recall this for discovery. And what I'll do, counsel, if there's no objection, I'll recall it in 45 days because it may take time for the CPS records because, sir, this is how Child Protective Services work. If the state already has the CPS records in their physical possession, then it'll be quite simple to get the CPS records. But if it's not in their hands or in the prosecutor's hand who handled the CPS cases, it's going to take a while. Because if you can imagine, in Bexar County, Texas, there are a lot of Child Protective Services cases and they have to pull all of the records. And sometimes the records will be duplicates. So your attorney may end up with 2,000 pages of records, but only 1,000 of them are original. All right. So I'm trying to make sure that your attorney has all of the evidence so she can represent you. All right. And not be hit with surprises. Okay. So what I can tell you is I'm going to get a 45-day reset. if she has everything before that date, all she has to do is come back to court and say, I have everything, and we'll bring you back in court before the 45 days. Do you understand? All right, Ms. Ferguson, I need a 45-day reset.
It'll be April 3rd. That's 44 days.
All right, we'll bring you back on April 3rd, and that's to make sure that she has all of the discovery.
One last thing, Your Honor.
Yes.
My client and I have discussed what is missing, but we are still waiting to see for an offer from the state this morning. So if I can just have a few more minutes with him
I'm sure.
before they take him back. Your Honor.
Yes.
Thank you, Judge.
You're welcome.
Morning, Your Honor.
Good morning. So, Mr. Foley, I haven't seen you since our last trial here together.
It has been a minute,
Yes. So any new vegetarian places?
really. I think there's just, they don't, a little bit of.
No, I'm not, but I am,
You're
I enjoy
dabbling?
good food.
Okay,
So I love all things green.
okay.
Right? It took me a while to love Brussels sprouts, but then I just realized they were not being cooked appropriately. And I discovered once you cook them appropriately, they're
okay.
no longer healthy. You know, when you throw in the maple syrup and the bacon, it's like,
Yeah,
not healthy. But Sean, am I right?
yeah, that's fine.
Yeah, my mom would always, you know, you would have the day where you would have to have fish and you'd have the day where you would have to have cabbage. I'm from Louisiana, so you put the hot sauce on the cabbage, it's good to go. But when she would do the Brussels sprouts, I just can't eat the baby cabbages.
Can't do it.
Oh, I can't stand them.
Well, you haven't had them with bacon and maple syrup.
Yeah, I have, I still, it's like every good recipe or every recipe that people have for Brussels sprouts is just some way to try to cover up the
mask,
flavor.
right, it's
Yeah,
true.
of
Well,
Brussels
you know, it's the same thing for me with kale.
sprouts.
I will agree with you there.
Me too.
Yes, but I will tell you, one of the best places I've had for Brussels sprouts, which they're not healthy once I've started counting calories, Cheesecake Factory, their Brussels sprouts are
Oh, they're
great.
good.
Oh, yeah.
Oh, they are.
Okay,
And you're just,
all right.
and
good to know.
also Zokas.
Oh, yeah.
On the Riverwalk, their
Right.
Brussels sprouts are great. All right, so today,
And now the unpleasant matter of.
yes,
Excellent.
it's never unpleasant because I get a chance to see you all. All right, so today is plea deadline date.
Yes, Your Honor.
So are you all requesting a jury trial?
Well, Judge, at this point, the court might recall, I just brought you an order for additional funds for the mitigation experts. So
Yes.
they are trying to finish that up so that Mr. Foley and I can present a mitigation packet to the committee so that we can make a plea bargain offer to Jason for him to take upstairs. So what we would actually like to do is extend that plea bargain deadline if we possibly could, so that we could make that happen.
And Judge, we do have authority from our client, Explorer Police, so we do think this thing.
So how much time would you all be asking for?
I would say 6 weeks if possible.
All right, so Miss Ferguson, I'm gonna need 2 dates from you. First, I need a date for 6 weeks from now.
April 1st.
All right, is that April's Fool's Day or is that the real date you're giving me?
It is April Fools.
All right, and then the next date I need is a jury trial date. How long would you all expect a jury trial to last?
I'm gonna say, I don't know, Jason, what do you think, in 2 weeks?
Yeah, Judge, I mean, probably a little less than Tamor McIntyre, so probably 2.5. I mean, 1.5. rather.
All right, so I've been in trial with Mr. Foley before.
So
Which
that's
is,
what.
there is a
So
folly
there was-
There's
factor.
not that many videos, but I mean, if
There is a
So-
folly factor. I will agree with that.
Which I'm fine with, but I just want us to be prepared. All right. Because if there is, I just need to be prepared because I was in trial with Mr. Foley and I actually enjoyed, because both attorneys were very well prepared. But it was a trial where the next thing I know, I said, how long have we been in trial? Has this been 2 weeks? And Deputy Lawrence, like, Judge, we've been in trial for a month.
Yeah, I know.
Yeah, so
But you're gonna say 3 days.
no, it was longer than a month. Like, oh my gosh. So
And that was on an ag assault.
no, that was a murder case.
Remember, the murder was the other kid.
Mhm.
The capital murder was the other kid. This was the ag assault. From the second kid, remember, because they brought the victim in and put him on the.
No,
Oh, no, I'm
no,
sorry. No,
no.
you're right. It's Briones.
I was like, yeah, he's challenging my memory.
Yeah, right.
Not happening.
Like Ingrid Bergman, is this gaslight?
I tried
Are you trying to
this.
gaslight me?
Tried those two back to back, Judge, remember?
Yeah. All right, so what date?
I think they're pondering here.
All right, and there's gonna be a gap of time because we have capital murders and murders that are already set.
that's, yeah, that's a holiday.
Well, the beginning of November is an official holiday.
Oh, I know that, Judge.
That's what a Scorpio say. Oh, but
November 11th is a holiday, Judge, for Veterans Day.
yes.
Unless y'all pick on a Monday.
And I will tell you, I always tell jurors, don't wave the flag and then not want to serve on jury duty because only two things are asked for you: pay your taxes and serve on jury once in a blue moon. So what are you all saying? Do jury selection on when?
The 10th, Monday, the 10th, and then
All right.
start the 12th because the 11th is holiday.
All right, is that going to interfere with people's Thanksgiving plans?
The Thanksgiving should
It
be,
possibly could.
Oh, yeah, good point. But if-
Well, that is a good
Yeah,
point.
that
No,
puts
we're
some-
gonna move with a purpose. So let's do that jury selection then on, if the holiday is on November 11th, do people usually take that Monday off
They
to
do,
travel?
they do. I
Mhm.
try to.
All right, then this is what we can do. We can either do jury selection on the 10th or we can do jury selection on Wednesday, the 12th. And if we do it on Wednesday, the 12th, we'll start in the morning and everybody has all day for jury selection. And state, I won't expect testimony on that day. It would just be for jury selection.
That'd be fine to state, Judge.
I think that's probably best, Judge.
All right, so November 12th.
November 12th, Wednesday.
And then if I end up with my mom for Thanksgiving, Angelini will finish you up.
What a treat and a treasure.
Don't threaten me with a good time.
What a treat and a treasure.
Or either I have my mom come down. Mom, can you come down? All right, so November 12th.
Okay.
And then if my mom comes down, she'll say, no more objections. That's my baby. All
Get
right.
this show on the road.
Yes. So this is what is happening so you can understand. So everyone is going to be back here on November 1st. Your council will
April
have-
1st.
April 1st. Why did I say November 1st? April 1st. Your council will provide whatever mitigation they want the state to review to see if there's an agreement that can be reached. State, if you need time to look that over, there may be another date before your November 12th date if they need more time. But November 12th, because of everything that's going on with discovery and so many moving parts, that's going to be your jury trial date and your plea deadline date. Do you understand? Do you have any questions about anything? All right, anything else from either side?
No, Judge.
All right, no more face tattoos, okay? All right,
Yes, thank you, Judge.
you're welcome.
Morning, Judge.
Good morning, how's everything going?
Busy for Tuesday,
Yeah, because when.
Monday, ruined.
Yes, it's Monday and a Tuesday.
Yes.
I kept saying Monday. And then people were like, no, tomorrow's Wednesday. I'm like, okay. All right. So on this case, we're here for a violation report. Is that correct?
Yes, Judge. He had a PR bond on a PG 2-1-4 awaiting indictment.
Mhm.
And then he also had a less than 1 gram subsequent to that. He's on a PR bond for the first case and then the YSL bond company for the second case, to my knowledge.
All right. So state, in regards to these cases that the court has for the violation report, it's for drug cases.
The office.
And the
date-
office date is 2023. Have there been any labs?
Judge, I know on the newer case that, from 2024.
And in the meantime, could I tell you a little bit more?
Sure.
Mr. Chavarria is working, he's 19 years old, correct? 18 years old, he's working at a car wash place, he gets $19 an hour. He paid for his bond, he got a PR bond for one, but he's been paying for his bonds, he's been checking in.
Okay.
He's made appearances in County Court 12, he's never missed a setting.
Okay.
And he's scheduled to be in County Court 12 next.
So why was he
week.
rearrested? Because the violation report I have, the only reason why you're here is because they said you were rearrested on the County Court 12 matter and then a drug case matter. And then,
Yeah, you guys-
sure.
And so we just received a wrap on the 2023 case, like 5 days ago.
Mhm.
So I, will get one on indictment or attempt to do it myself.
All right, let's go just one moment.
I can give these back to you.
Because it appears that your client is doing well, counsel.
Yes, Judge.
I will continue him with the same conditions. And then what we can do is we can recall this to see about the other cases, and maybe that may take care of everything. You understand?
I think that the reason for the violation report is because he was rearrested for DWI as UCW and being arrested on February
Yes.
6th.
Yes.
So I just given
Okay, we can go on the record. All right. We're on the record in Night Mag number 743-129, State versus Emmanuel Chavarria. Can I have parties announced for the record for the state?
state
If it's-
Joseph Stateson.
And you're Mr. Chavarria?
Yes, ma'am.
All right, the court is in receipt of a first violation report and a second violation report. Based upon the violation report, it was filed due to your being rearrested on previous cases. And I'm assuming, since it says rearrested, he had made bond for those cases previously. Is that correct?
To my knowledge, he had made bond on all those misdemeanor cases as well.
All right.
He was already magistrated.
So, state, what are you requesting in regards to the violation report? All right, defense.
A judge, my client's working. He's 18 years old. He can't afford to lose his job. He posted bond on his misdemeanors, and he has his mother here in the gallery who's relying on him to make house payments, utility payments. He does have one child who lives with him. He's not married, he has a girlfriend. One child is expensive and it's a lot. And he has expenses for child support, not child support. He doesn't owe child support. He's appeared in County Court 12 every time. He's never missed a setting. He checks in with pretrial. He's willing to report more frequently. He's asking if he could have his bond stay the same, and if not, have if we could have like a summons and have a pretrial setting to see about disposition within 30 days.
All right. And Mr. Chavarria, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Emmanuel Anthony Chavarria.
All right, on your bond for the driving while intoxicated in misdemeanor court, are you required to do any type of drug testing of anything of that nature?
Drug testing. What do you mean?
Your analysis. Does anybody test you to see if you're using alcohol?
My job, they do daily, like monthly drug tests and stuff.
All right.
If they see that you're acting weird, that they'll drug test.
All right, so you're receiving drug testing through your work?
But sometimes just not.
All right, so my question is, you have cases in misdemeanor court. Do you understand that? One of them is driving while intoxicated, and I don't want to get into any of the facts of that case or what people think the facts are, but are they giving you any type of drug testing for that case? Do you have to urinate and have people check your urine?
No, ma'am, I haven't got drug tested for that case.
All right.
They took blood though. They took blood out of me.
Okay, that's related to something else, to see if you had alcohol in your system while you were driving. Have you ever used any marijuana in the past or anything of that nature?
Like when they had to pull me over, yes, ma'am.
Okay,
But not that day. I wasn't smoking or drinking that day.
okay.
I just had it in my possession.
Okay, all right. So this is what the court is going to do. The court is not going to increase his bond. And I know judges are not supposed to tell why, but let me just tell everybody why I'm not increasing his bond. The drug cases have been pending since December 2023. The state only recently received the labs. And if either party wanted to, these cases could have been dismissed for further investigation under 32.01 of the Texas Code of Criminal Procedure. So I'm not going to increase your bond, and state it. Of course, it's up to you whether you're indicted or not, but he's 18. He doesn't have any more money to afford any more bonds. What I can do is I can reset the night mag cases before you indict, if that's the route you choose, and defense, you and your client can appear. And if you all are able to reach agreement, then that's completely up to you all. If you're not able to reach an agreement, then we'll head towards jury trial.
I would like to have a chance to negotiate for resolution.
All right, so state, we can go off the record. State, are you in, I know he's going to ask for how much time?
Within 30 days.
All right, so he's going to ask for 30 days. Are you all going to indict that before 30 days or?
No, I'll confirm.
All right, so what we'll do is we'll recall this. Ms. Ferguson, if I could have a 30-day reset on Chavarria for the night mag cases, and they're going to ask for drug testing. I'm going to ask that the fees be waived based upon his finances.
March 20th.
All right, so we're going to come back on each of these cases on March 20th. And you work, is that enough time with your employer?
Yes, ma'am. I'll tell them if I can get that day off.
All right, if for some reason you're not allowed to have that day off, counsel, he can appear by Zoom.
Yes, Judge. Thank you.
Is there anything else?
No, ma'am.
No, Your Honor.
All right, thank you. Once you sign the reset form, you're excused.
Let's see that. Yeah.
All right, David Rocha.
Yes, ma'am.
All right, you need to show your video?
Can you see me?
Yes, I can.
Okay.
So this is set for hearing. He's requesting early termination.
Yes, Judge. A status report for early discharge was sent into the court last week or so. And at the time it was sent to the court, it was denied. The state opposed the discharge and Mr. Rocha would like a hearing to discuss it.
All right, so Mr. Rocha,
Yes, ma'am.
attorney, and I don't know if he's still your attorney or not. Mr. Allen,
Right.
he's not going to be available till another 30 days. So if you want to wait for him, if Mr. Allen is still your attorney, we can wait for Mr. Allen.
I don't mind.
It may be in your best interest to have him represent you as far,
Okay.
if he's still your attorney, as far as the early termination is concerned.
Okay, we can do that.
All right, so Ms. Ferguson, what date, because they sent out an email with Mr. Allen requesting that his cases be set off for 30 days. What date do you want to bring this back?
I think March 31st.
All right, so what we'll do is we'll set it for March 31st.
Okay.
Okay,
Sounds good.
all right, thank you.
Thank you.
You're welcome. Bashan, I had no idea that Matthew Allen was his attorney till I looked it up.
Oh, right, Judge. After speaking with the state, he gave me the reasoning on why he was opposing at the time. And he was just gonna tell you why, but Mr. Rocha has finished everything and he's doing well. So hopefully on the 31st, we can come
Yes,
to some resolution. Thank you, Judge.
you're welcome. Thank you, Mr. Rocha.
You're welcome. Bye-bye.
Bye-bye. Hello,
I can be a text message.
who's your attorney?
I don't remember his name, honestly.
It's Robert Mauer.
All right, your attorney is out of county in Travis County. And he's asking that your case be recalled for tomorrow. So we'll bring you back tomorrow to take care of your matter.
Yes, ma'am.
All right, do you have any questions about anything?
No, not really.
You sure?
Yes, ma'am.
Okay, all right, we'll call you back tomorrow. Sorry for waking you up.
That's
All right, thank you.
Just, that's a Wednesday, is that? It's okay, Wednesday?
Oh, it is Wednesday. I forgot. We're on Tuesday, right? So then what I'll do is I'll call you back on Thursday. I'm sorry. I forgot that it still feels like a Monday. It feels like a Monday.
Yes,
Definitely
ma'am.
hit me here. So Monday and Tuesday, whenever we're off on Monday, Tuesday becomes a Monday and a Tuesday
Oh, okay.
because we're playing catch up. All right, so we'll bring you back on Thursday, okay?
Yes, ma'am.
All right, thank you.
And get it is also out here, Judge.
All right. Mr. Guerrero, can I see you? Hello.
Good morning.
Good morning. Your attorney is actually out of county.
Okay.
So what I'm doing is I'm going to call you back for your plea deadline date on March 17th. And on that date, you need to let the court know whether or not you've reached an agreement with the state. Do you understand?
Yes, ma'am.
Do you have any questions?
No.
All right, thank
All
you.
right.
Vashawn Gibson is being recalled for the 20th. State, did you tender an offer?
Your Honor, at this time, we have been conferring, we had tendered an offer, defense has a counter offer. Before the state can actually consider that, we're just waiting on CPS records.
All right, so where are the CPS records? Because this case has been on the docket since November.
We subpoenaed them last week, Your Honor.
All right, so are they in the cut? Is there an open CPS case?
There is,
I don't know if there's a legal case, Your Honor. I think there's just on the regular CPS side.
I think it's in family-based.
All right,
as
so
non-legal.
has anybody reached out to the CPS caseworker?
I can ask our advocate to do so.
All right, I'm recalling this back for February 20th. That's Thursday.
We can do it next, well, any chance for the 27th?
All right,
Just a week later.
all right, I'll put it on.
And Judge, while we're here, my client's been in custody since September. We respectfully request a oral motion for a bond reduction with,
Well, the way the law is now, you'll have to file a motion and I'll hear it and we'll put it on the docket as soon as you file it. If the state is waiving notice.
I think there's one on file, but we'll get it set for the
If it's
20th.
if it's on
I
file,
think my client, actually, Judge.
all right, if you want to adopt your client's motion, if the state is waiving notice, then I will hear it.
Your Honor, I would need to look at the motion and maybe just confirm, see if there's an agreement that can be reached.
Okay, Judge.
All right.
I'll just file one, let's just do it for the 27th.
Well, they're saying that they'll look at the motion and see if you all can reach an agreement. So do you want to talk to them now? Or do you want to file your own and come back on the 27th?
We'll chat right now.
All
I'm
right,
here.
thank you.
Let's chat.
Sure.
Have a seat, sir.
All right, so Mr. Salazar, I'm in receipt of the motion that you filed. What I can tell you is, unless there's an exception, PR bonds, based upon the legislature and the rules they pass and the laws they pass, PR bonds are not given for violent offenses, and because this is an aggravated assault with a deadly weapon, you're not going to be able to receive a PR bond from the court unless there's some exception that your attorney wishes to present to the court. So with that being said, the court is calling, let me find you, 2024 CR 009128, State versus Cody Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense.
Robert Gear for defendant Cody Salazar, Judge. We're ready.
And are you Mr. Salazar?
Yes, ma'am.
All right, and defense, are you adopting your client's motion to set, well, it's a motion to grant a personal bond. Are you adopting that motion?
Yes, Judge, we'll adopt that motion and we'd like to argue, if not for a PR bond, for a reduction in bond as well.
All right, so state, the motion that the defense counsel is adopting is a motion requesting a personal bond. That's it. It's not a motion for a bond reduction. So any objection to defense counsel amending his client's motion and requesting a bond reduction?
No, Your Honor, and I will state for the record that there were a couple motions filed. I do believe one of the ones the defendant filed was a motion for reduction of bond.
All right, do you have that motion? If you all could print that out? All right, so defense, it's your motion. You may proceed.
Yes, Judge, may it please the court. My client was arrested on or about September of last year. We've been coming to court since November. State's attorney is correct that we have been conferring at every court setting. However, we're still here in the need of more discovery in the way of CPS records. And since my client obviously has been to court every day, but not only him, his family's been here, his mother and sisters have been very supportive of him. Bond and bail should be set in an amount that is sufficient to require or have the defendant submit to court and make all his court appearances. There is also a condition that I saw on the bond by the magistrate of a GPS with house arrest, and considering the nature of these charges and that bond condition, I believe it'd be in the best interest of society and my client and myself as representing him and being able to discuss this matter with him, that the court reduce his bond to a reasonable amount so that he can bond out, number one, because he has been sitting there without much movement on the case because we're waiting on discovery and waiting for CPS records. Number two, it'd be easier for myself and him to communicate were we out, should we have to prepare for trial or any hearings or other further settings in this matter. Considering the conditions on his bond, we believe that those are adequate enough to secure himself with society and in the eyes of this court. And therefore, Judge, we'd respectfully request that the court reduce this bond to a $20,000 to $40,000 bond range, so that my client, with all the conditions that are already in effect, will move my client's constitutional rights. Thank you, Judge.
All right, so what bond are you saying he can make? And do you have any testimony to determine the bond amount that he can make?
I call Cody Salazar, Judge.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Cody Salazar.
All right, defense, you may proceed.
Thank you, Judge. Cody, at the time of this arrest, where were you residing?
I was at my mother's.
And you've resided there for quite some time? And you have been incarcerated how long?
5 months now.
Okay, so you currently don't have any occupation, and you're not working. And if you were to be released, you'd have to look for a job because you don't have one waiting for you, correct?
Yes, sir.
But your mother does work, correct?
Mhm.
And she's had a steady job for quite some time,
Yes.
and she cannot afford a huge bond as the current bond amount. Is that 100,000? That's a little bit out of the range.
Yes, sir.
Do you believe she'd be able to afford a $20,000 or $30,000 bond?
Right now, I have to ask her. I mean, I don't know, I don't really know.
Would it be easier for her to afford in the bond in that amount than what the bond is currently set at?
Oh, yeah.
And property, other than her house, does she have any other property that she may be able to sell or get money for a bond?
I don't think so.
Okay, do you have any property that you'd be able to sell and get money for? So you're asking this court to reduce your bond to an amount that you believe that your mother would be able to afford to get you. Sorry.
All right, so we can go off the record. So what I need is, what have they done to secure a bond? How much money do they have? Do they have any money in the bank? So,
Judge, if I may?
Yes.
May I call another witness?
well, just one second. Any questions, State?
No, not for this witness, Your Honor.
All right, thank you. Yes, you may call another witness. Yes, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Annette Salazar.
All right, defense.
Ms. Salazar, what is your relationship to Cody?
I'm mother to him.
And when, prior to being incarcerated, where was he residing?
He was living with me.
Okay, and his bond is currently set at $100,000. Is there, what, have you made any inquiries or tried to get a bond in that amount, or is that above?
Yeah, that's way too, I can't afford.
And are you currently working?
Yes, sir.
And what do you do?
All right.
Where I
so-
work here? Sorry.
Just off the record for a moment. I know the witness. I think everybody knows the witness. We know where she works,
All
so
right.
you don't need to get into any of that.
Okay. And we're here today asking for a reduction of your son's bond. Is there a certain amount that you think that you would be able to afford?
I mean, I don't really have a lot, like to say, maybe 500 I don't really have, but I mean, I maybe take them out with 500, but I know it's not crazy, I know. But I like,
And you did hear the judge's announcement and
right,
about a request for a PR bond is not
right, they couldn't do it.
acceptable in this
Right,
case.
yes.
And so you think that $500 may be the maximum amount? Do you have friends or family that you could borrow any money from that may be able to assist you in getting this bond?
It would just be hard for me to pay that back, and I don't want to be in debt, I pay my bills and I try to, it's just.
Do you have any property that you'd be able to sell that's unencumbered by any debt that may be able to?
No, I do not,
That's all I want, Judge.
sorry.
All right. Thank you.
I'll pass it to Ms. Judge.
Any questions?
No questions.
All right, thank you so
I'm sorry,
much.
thank you.
Thank you.
All right, any other witnesses?
No, nothing further, Judge. We'll rest.
All right. State, any witnesses or evidence?
As far as evidence, Your Honor, the state would enter in, I guess the police report, if you can give me just a moment to grab that.
Okay.
Defense has reviewed it, Judge. We have no objections.
All right, let me just review this. All right, the court has read State's Exhibit number 1. The court will hear argument from both sides. Defense.
Judge, based on the client situation, the fact that we've had several court hearings and we've conferred with the state, we believe we're moving this case along. My client's been incarcerated since September. Considering the fact that we're waiting on more discovery and that there are special bond conditions put in place, we respectfully request that the court reduce his bond in the amount that he may possibly or his family may be able to afford. Thank you, Judge.
State.
Yes, Your Honor. Regarding the discovery, we did just confirm the existence of it last week as well. I'm sorry, on the
Yes, sir.
6th. On February 6th, we confirmed the existence of that discovery, and we did send a subpoena out last week as soon as we found out about it. So the state is doing everything in its power to get those records as quickly as possible. On the other end, Your Honor, this is a violent offense. The facts alleged, as the court has read, are violent, and this victim is scared for her safety. Additionally, the defendant is a convicted felon. He is a repeat offender. He's got a prior conviction for in 2017. for the second degree felony offense. And because of those two things, Your Honor, the facts of the case and his prior criminal history, the state believes that he is a danger to this complainant and to the community, and would respectfully request that the court keep the bond in place at $100,000.
You have final argument.
Judge, there are special bond conditions to ensure the safety of society and for the victim. My client and this victim have not had any communication in over 3 years. I would be going to his home under house arrest where the victim is nowhere to be around. So to argue that he may be a danger to her is inadequate at this time. Therefore, we believe that the issue here is what amount of bail is sufficient to assure his attendance in court. And therefore, we respectfully request the court lower the bond to $20,000. Thank you.
All right, and state, has the defendant ever failed to report to court and previously in other cases?
Let me double check that.
All right, this is what,
I'm sorry, the only thing I have is that he was a post indictment.
and then we understand why post-indictment fugitives happen. It has
Yes.
nothing to do with his not appearing. All right, and then the court does notice that there are potential mental health issues. So you're still under oath. Have you ever been diagnosed with any type of mental health issue? Have you ever received or seen a psychiatrist?
I think at a young age, I was.
Okay. All right, this is what the court is going to do. Court is going to set the bond at $85,000. There's to be no contact with the complainant and no contact with minors. There's to be full GPS, waive fees, and there's to be a referral to Center for Healthcare Services. Is there anything else from either side?
Oh wasn't appropriate, would you be willing to give my client time to
Yes,
come back and turn herself in?
yes.
Okay, thank you.
You're welcome. All right. So, we were scheduled for jury trial, January 21st, but I'm sure we're in jury trial on some other case or,
No, that was one of my medical issues.
yes, okay. I didn't want to say that, but yes, you're right. So, you're scheduled, she's still requesting jury trial?
She is requesting jury trial, Your Honor.
All right. State, would you be ready to try this tomorrow?
No, Your Honor.
All right. Would you be ready to try this on Wednesday?
Tomorrow is
Tomorrow is
Wednesday.
Wednesday.
Oh, tomorrow is Wednesday. Next week?
I don't know, but we'll make our best effort.
No, I thought we were set for trial today.
No, today, I know you had your medical treatment and I just put this as a tentative date because of the medical treatment. So,
I'll send out notifications to our witnesses and see who responds and what they have to say.
okay. I'm trying to get you set as quick as possible.
Thank you.
On all three cases.
All right, this hearing was scheduled at 9 a.m. It is now 10:32 a.m. The defendant did not answer docket this morning. And Deputy Laura, did you make an announcement?
Yes, Your Honor.
All right, defense, have you had any contact with your client?
No, Your Honor.
All right, state.
Judge, the state's requesting a judge's warrant of bond forfeiture.
All right, the court will grant the bond forfeiture in each case, remand your client without bond. If your client makes an appearance, the court will reconsider. And with that, the record will be closed. Thank you.
May I be excused?
Yes.
Thank you, Your Honor.
And she has 3 cases. Mason Washington